Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Hyenga against Gilbert. Our cause number 1CA CV130489. Counsel, you've all been here before. You understand our processes. We have conferred on this case before coming into oral argument and have reviewed all the briefs and records, so you can bear that in mind as you begin your videotaped presentation. Each side will have 20 minutes for argument. From the appellant's side, you may reserve as much time as you wish for rebuttal, but you have to watch the clock, and when the clock hits 0, that's the end, okay? And with that, we can begin.
Thank you. Please, the court. Miriam Hyenga essentially made two claims against Buse Gilbert. One constellation of claims involved the 1997 alleged misrepresentation that she had 120 units on the property. The other constellation of claims involves the city's lie in 2000, to which they admitted that she only had 12 units and had to do a major rezoning. The two claims are related but separate. The first claim has to do with the damages against Gosnell for the fraud, the difference between the value of 120 units and the value of 12 units, around $1.4, $1.5 million, plus the attorney's fees that were awarded against her on November 8 of 2007 in favor of Gosnell for around $300,000.
I may have misheard you. You're not suggesting that part of the claim here is based on a 1997 misrepresentation by the law firm?
No.
Okay.
No, not by the law firm. A 1990
by Gosnell?
Yeah.
Okay.
A 1997 alleged misrepresentation by Gosnell. Gosnell told her 120 units. The city on 3 occasions confirmed 120 units. That was alleged to be false, because in 2000 they said 12 units. The concealment of the lie affected Miriam's claim against the city for lying in 2000 that she only had 12 units and had to do a major rezoning, which cost her her 2000 sale to the Hilton for $4.5 million. That was a claim that she didn't know she had until the trial in 2007, when the city got on the stand and admitted that the error was really theirs and not Gosnell's. This case should be resolved principally because of Amfac versus Miller, and because of the rule that the statute of limitations only begins to run when the injured party ought to know that and ought to have fixed ascertainable damages. And in this case, there were no ascertainable damages, none.
Are you asserting that the absolute sum to be sought, almost like a 12821 claim, ought to be known before it's filed? Or are you saying that they know that the existence of damages?
In 2007, Ms. Hyenga did not know that Buse Gilbert had concealed their knowledge of the city's lies in 2000. The city's lies in 2000 basically cost her the Hilton sale.
Right.
She didn't know that.
But that's not really an Amfac contention, is it?
Well, yes, it is, because Amfac holds that in addition to needing to have knowledge of the negligence and who committed the negligence, there must be fixed ascertainable damages.
Right, but the state of your client's knowledge as to some of the facts that may give rise to liability That's sort of garden variety accrual, that you don't need AMFAC to get there. And I don't see that the argument that there was delayed understanding of some of the facts she might later allege against Buse Gilbert is really part of your argument on appeal. As I see it, the question is, does your malpractice case allege litigation malpractice or some other kind of malpractice?
Okay. It alleges litigation malpractice because it was in the course of the litigation.
Define that for us.
Define litigation malpractice?
No, define in the course of.
Okay. From 2003, when the complaint was first filed, until August of 2007, when the case was tried, sometime in that period, no later than 2005, Buse Gilbert learned that the city had reduced the number of units from 120 to 12 in the year 2000. And they did it because of a mistake they had committed in 1995.
They, who?
Buse Gilbert learned it during the course of litigation.
Because of a mistake they had made.
Because of a mistake the city had made in 1995. In 1995, the owners of Parcel 2, which was a commercial parcel, applied to change it to residential. But that parcel had no residential units allocated to it or proposed for it. And the city, without authority, simply took 120 units from other residential parcels and placed it in Parcel 2. So that when Miriam came along in 2000 and said, okay, I have a sale to the Hilton, the city said, well, there's 120 units that are gone. They made them gone in 2000. They were not gone before 2000. She didn't know that. Buse Gilbert did. They knew it at least as early as 2005 and may have known it or been in a position where they should have known it in 2003. When she sued the city in 2008 for their essential fraud relating to the 2000 representations, the city raised statute of limitations, to which she said, I just found out in August of 2007, you guys concealed it until then. And the city said, no, no, no. Your lawyers, Buse Gilbert, knew this since at least as early as 2005, and they were able to demonstrate that in the record. And they disclosed the statute of limitations defense, and they filed a motion for summary judgment, which they lost, and they filed a second motion for summary judgment, which they lost. But that issue was still in the case. The case involved an admission of liability. The damages were clear. The only real issue was the statute of limitations.
Can you take me back to my question about the course of litigation? Now, you've given us the chronology.
Yeah.
When did the course of litigation begin?
2003, January.
What signaled it?
The filing of the complaint.
So counsel, no events in 2000 were in the course of litigation?
In 2000, when the city first said, I don't think you have 120 units, she went to her zoning lawyer, Paul Gilbert, to discuss it with him.
Didn't he then send her on to other counsel with the idea that he would later bring an action against
Yes.
No.
Yes, he did. He said, use another lawyer to get the units increased. After you have done that, I will sue Gosnell for the missing units.
So does in the course of litigation include preparation for litigation or discussions of litigation?
Well, yes.
Where's the,
In other words,
Yeah,
if
yeah,
a
it
client
does.
comes to you with a personal injury case a year after the event and says, please file a complaint, and the lawyer doesn't file it for another year and a half, blows the statute of limitations, Does that count as in the course of litigation, or is that a different kind of malpractice?
No, it's in the course of litigation. But the AMFAC rule applies not only to litigation, it involves to commercial settings, non-litigation. That's clear from the Arizona cases that it doesn't require litigation for the rule to be applied.
Well, how would the rule be applied without litigation?
All right, one of the cases involved...
I mean, the whole reason we talk about AMFAC as opposed to other cases is that it speaks to the exhaustion of appellate remedies and conclusion of litigation.
All right.
So how does that work in a transactional setting?
All right, here's one of the Arizona cases. A lawyer puts together a real estate transaction. He fails to get security for the note. He recognizes that he had failed. He tells the client, I failed to get security for the note. I think that's the case in which he says, I think you better talk to a malpractice lawyer. She doesn't. They pursue the debtor. And only after the pursuit of the debtor comes up with a zero and the appellate process has been exhausted, does she bring the malpractice case. The lawyer says, I told you about this more than 2 years ago. She says, I didn't know whether I was really hurt until the exhaustion of the appellate remedies in my separate case against the debtor. And that case says the AMFAC rule applies to non-litigation cases as well.
So does the AMFAC rule apply to all cases?
It could. It could. If the issue is the damage
isn't really curable by litigation.
What's that?
What if the harm isn't really curable?
Then it
by
doesn't
litigation?
apply.
Okay, and this is a feature of the AMFAC rule that I think makes many uncomfortable, which is that it gives the plaintiff quite a bit of discretion over when accrual happens in a malpractice case, because the plaintiff is always in control of whether to bring litigation, whether to continue litigation, or whether to abandon litigation.
Well, let's take the case of the promissory note that's not secured. If the plaintiff is in a position to collect his money, he has no damage. If the absence of the security agreement doesn't matter, the debtor has a tremendous amount of assets other than the security, and he collects, there's no damage. So if he brings an action against the lawyer before he has exhausted his case against the debtor, the lawyer can say, you don't even know that you're damaged yet. And that is exactly what happened here. She didn't know that she was damaged by Bruce Gilbert's concealment until she settled her case with the city based upon the potential that the city could possibly prove a statute of limitations defense.
You're not suggesting that she had to sue the city, are you? In order for a malpractice claim to exist, couldn't she have said, "Look, I don't have time, energy, and effort to go after the city. That you left me high and dry. I don't need to."
Yeah, but as a malpractice lawyer, I wouldn't much like that case, because I would need to prove what would happen if she sued the city. And I would need to prove that the city would be unable to defend on liability.
But you just said, you've said about 7 times
Yeah.
here that the city lied.
Yeah.
If liability was that clear, why sue the city? Why make that a prerequisite? It's almost like we're making all these, it sounds like you're making that a prerequisite to the claim, to the malpractice claim, to the accrual.
It is. It is a prerequisite. If she fails to sue the city, she's going to have to prove what would have happened if she had sued the city. But if she sues the city, she is not damaged by the concealment, because the city may waive the statute of limitations. The city may lose the argument. She may lose her case against the city. If she loses her case against the city.
On the merits.
On the merits. She has no claim. She may win her case on the merits. She has no claim because she'll collect the damages from the city, and there'll be nothing left over to sue Buse-Gilbert for. There's only one way that Buse-Gilbert becomes responsible for their misconduct, and that is if either the court in the city case throws the case out on statute of limitations grounds, or if she settles solely because of statute of limitations, and that's what happened here. The city paid $2.5 million, not for nothing. They paid it because they saw that the liability had been admitted, the damages were clear, and their defense was statute of limitations. But not something that Ms. Hyenga knew, something that her litigation counsel knew. And the issue is, would that have carried the day? And until we know that, there's no claim against Buse-Gilbert. No, on the rest of it, the $300,000 attorney's fees, that judgment wasn't even entered until November the 8th of 2007. That clearly is within the litigation rule. That litigation was not resolved until April of 2008, so she had until April of 2010 to bring that part of the claim. I wonder if I could reserve my last 4 minutes.
Certainly.
Thank you.
Good morning. Good morning, Your Honors. Gary Birnbaum for the defendants' appellees. I want to begin with a direct response to the court's questions and to Mr. Leonard's comments, and then perhaps I can retreat to what I expected to address. My friend, Mr. Leonard, unfortunately, I believe, is conflating 2 very different concepts, and the court's questions seem to focus on that conflation of 2 concepts. The first one is claim accrual generally. There are 2 elements in Arizona to the accrual of a claim. You have to know or should know that there's a claim, that somebody has done something that allegedly harmed you. And then the second thing is you have to know or should know of the fact of damage, even though all of the damages may not have accrued yet, even though there may be events that affect the amount of damage in the future. That's the general accrual rule, supported by more cases in Arizona than I need to mention. Now, there is a second exception to that rule. In a legal malpractice case, when in the course of litigating that case, a lawyer purportedly makes an error, and that error can be corrected on appeal, and the lawyer's conduct can be vindicated and any damages can be eliminated, then AmFac 2, as we call it, says that the statute of limitations on that narrow, limited legal malpractice claim that arose during the course of the litigation will not accrue until that litigation is completed. Those are 2 extraordinarily distinct concepts, both now recognized in Arizona law. But to suggest that AmFac 2, affirming AmFac 1, to suggest that AmFac is not a litigation rule is just wrong. And it's so wrong that if you look at the appellant's briefs in this case, their reply brief in particular, the section headings are the AmFac litigation rule applies in this case. We don't agree, but that's their section heading, that the AmFac litigation rule should allow the statute of limitations to be extended, that the Gosnell case was continuing, and therefore the statute of limitations has not accrued yet. So there's a complete recognition in the cases and in the briefing, and I believe in this court's question so far, about this distinction between the ordinary accrual case and the narrow exception that exists in AmFac.
So having joined issue on the idea that the outcome of this appeal likely hinges on the applicability of AmFac, why doesn't it apply?
AmFac has absolutely no application in this case, as Judge Anderson found. The simplest short reason is this. First, there's two, I'm sorry. The first is that there is no allegation of malpractice in the handling of the Gosnell case. The predicate for...
I was able to extract those allegations. It seems to me that the allegations are essentially that Buse Gilbert failed to either do an adequate investigation or disclose information it knew to anticipate a defense and deal with that defense, a defense that Gosnell prevailed on, right? And that it failed to preserve a claim against the city.
Well, Your Honor, assuming for a moment everything you just said is correct, that's not the malpractice claim. The malpractice claim that's asserted here against Buse Gilbert is that Buse Gilbert should have sued the city many years ago, and or that Buse Gilbert should have taken some action which would allow the, quote, Hilton sale, which we don't think was a sale at all. There's no contract for sale. There's no binding agreement. But setting that aside, Buse Gilbert should have done something that would have allowed the Hilton sale to be saved.
Well, don't they also allege that by its handling of the issues involving the city, Buse Gilbert failed adequately to anticipate Gosnell's defense and failed to deal with it?
Well, I don't think that's a fair statement, Your Honor, but again...
Well, it may not be a fair statement of what actually happened, but that's what I take the
No, I don't think
to
that's
say.
even a fair statement of their claim. But even if it was, that's not an issue in the Gosnell case, because remember, and maybe I shouldn't have separated these 2 points, the underlying principle in the AmFac case, the reason for that narrow exception for litigation, is you must have malpractice in the course of your handling the case that's continuing. In the course of handling the Gosnell case, there must be malpractice. Now, let me be very clear. Which malpractice can be eliminated? The lawyer can be vindicated by the continuing proceedings. There is absolutely nothing in the Gosnell case, in this appeal that was taken, because there was an appeal taken, although interestingly Ms. Hyenga alleges that she knew at the time she took the appeal that there was absolutely no basis for it. Remember, she concedes that by the end of the trial, when the verdict comes in, she says, I can almost quote, "The verdict is correct. I now know there was no basis for a claim against Gosnell." Well, she takes the appeal anyway. That's fine. That's her right to file the notice of appeal, which, by the way, is all she actually did, and then resolve the case. But nothing in that appeal could vindicate the conduct of Buse Gilbert in allegedly failing to sue the city, failing to sue the city on time, failing to, quote, save the Hilton sale. You could have any result you want in the Gosnell appeal. It does not impact those allegations of malpractice. That, Your Honor, is why, and we're not saying the law is absolutely identical, but that's why we pointed you, just by way of illustration, to the Jordache case in California, because it is almost factually indistinguishable. There you have a party, Brobeck Flager, it's a law firm, that allegedly fails bring a claim or to assert an insurance coverage, and therefore its client pays $32 million in attorney's fees. Then the client sues the insurance company saying, I really have coverage. They settled with the insurance company for $12 million, and now they go back and sue the lawyer and say, I should get the difference from you. It's just like this claim against the city. The California court says, no, the statute of limitations on your malpractice claim began to run at the time when you knew you had a claim and knew you were injured. Your other claim may, in fact, help reduce the amount of your damages, but that doesn't stop the accrual of the statute. That is a separate claim that doesn't fall within, quote, AMFAC at all. If it did, it goes well beyond the questions that Judge Jones was presenting. What if she filed a zoning case? What if she sued 3 other parties? What if she waited to the end of the statute of limitations to sue the city? Does she get to push off for years the necessity of suing the law firm?
Well, what if there were motions for new trial filed after the verdict?
There were.
And
in the Gosnell case.
Yeah, in the Gosnell case. And so if the plaintiff in the Gosnell case had managed to get some sort of remand out of the Court of Appeals for a late disclosed theory by Gosnell, which was an issue floating around in those motion papers, and gotten a remand, you would say then the case hasn't accrued. So are you suggesting that we need to take a look at the likelihood of success on appeal?
No, Your Honor, I'm not saying that, and I
didn't think you were.
And I don't agree with your comment that we would say, well, it hasn't accrued. The malpractice claim has still accrued, and here's why. And I apologize if I'm a bit disorganized. This is where I was going to start, because I think this is the most important fact. On October 11th, 2007, Ms. Hyenga, and her lawyer says she wrote these letters herself, sends out 2 letters. So we have in her hand, in her words, her statement of her knowledge. She sends one letter to Buse Gilbert, her attorneys, and she sends another claim letter to the city of Phoenix. And here's what she says in those letters, and I'm combining them. They both go out on October 11th. She says, 1, I believe that during the Gosnell trial, the city admitted that it made errors. I think that's a grand overstatement, but we'll accept that for today also. So on October 11, 2007, she knows the city says that it has made errors. She says, Buse Gilbert, you didn't sue the city, and says, it looks to me like it's negligence, looks to me like you should have sued the city, looks to me like you didn't because you have some, quote, conflict of interest, and that's why I think you didn't sue them. This is all in her letters and her words. She says that although her case went through trial, succeeded, passed motions for judgment as a matter of law, and was submitted on the fraud claim to the jury in the Gosnell case, she nevertheless says, I now know, on October 11, 2007, there was no claim against Gosnell. There was none. The jury was correct. I had no claim. Well, you should have sued the city.
I think she said, yeah, the city should have been named in the original complaint.
No, actually, she doesn't exactly say that, but she asks why wasn't the city named. But that's a fair implication.
But at the same time, then she attempts to correct that by her 12-821 demand, right?
Well, what she does, Your Honor, let me continue with what she claims. She then says, I've been damaged, and I've been damaged because I've incurred costs, I've incurred fees, you've pursued the Gosnell case when I don't think you should have, I spent my own time. She itemizes the damages, requests something like $2 million and an indemnity against any future fees. Now, at the same time, she says, remember, she's now said, you should have sued the city. So now she goes and she files her claim against the city. And there she says, presumably tying the two together, she's saying, here's my claim against the city. This is the claim you didn't bring, Buse Gilbert. She sues the city, and she says, I've now learned everything I need to know. I have a claim against the city, in my view. You concealed things from me. As a consequence, I believe I lost the sale to the Hilton. And as a consequence of that, I've lost $4-point-something million plus earnings on top of the $4 million. And she says, I'm going to collect that from the city, which, by the way, could be the city or an insurance company or anyone else. She says, I'm going to go try to reduce my alleged damages, mitigate my damages through that other action. But she knows everything there is to know about the Buse Gilbert claim, including one more fact. She sends that notice out on October 11, and the city almost immediately, within a week or so, responds to it. As you know, the city doesn't have to respond. They could just sit and allow a statutory denial. No, the city responds in October. They deny her claim, and they tell her it's because it's untimely. Okay? You didn't sue in time. Now, that takes you to somewhere around the end of October. I ask rhetorically, of course, what is there that she could possibly claim she doesn't know other than the final precise amount of her damages?
What's the significance of a city denying a notice of claim? How often do they accept them?
Because they denied the notice of claim as untimely. So
they're not judicial officers?
No, of course not, Your Honor. But as of the end of October, if her own letter wasn't clear enough, it is impossible to argue seriously, with a straight face, that at the end of October, she does not know and has not acknowledged that she believes, she knows or should know, that Buse Gilbert didn't file suit against the city, that allegedly has damaged her, that the city is asserting the untimeliness as a defense, that she knows the amount of her damages, although admittedly there may be factors in the future that mitigate or reduce those damages.
But then
that's a claim of
litigation.
yes.
Then she pursues the litigation against the city and is partially successful.
But that's not AMFAC, because Buse Gilbert didn't represent her in the claim against the city. It's not the continuation of the case. Judge Swan, it's exactly what you asked. AMFAC is about a lawyer who handles a case, who allegedly does something wrong, who then on appeal of that case can vindicate his conduct and say, I didn't do anything wrong, it was the judge that did something wrong.
Where is the of that case language in any case? Like AMFAC, for example.
AMFAC is quite clear, Your Honor. I don't know if I have the exact quote, but the elements of AMFAC include that the lawyer's negligence in the handling of the case, a case, may be, the statute of limitations may be delayed if, but only if, one, there is an ongoing appeal of that case in the same action in which the malpractice occurred, so that the appeal can vindicate the conduct of the lawyer. That's why we defer, perhaps even unfairly, we defer the statute of limitations, because we want to allow the appellate court in that case a chance to correct it. If the rule were different, then you could have your malpractice claim, go out and file, I don't know, a zoning case, and say, well, until my zoning case runs its course for the next 5 years, I don't know exactly what my damages would be. But you know,
now, if the malpractice claim is failure to join a party in the case, and let's take it out of the Gosnell litigation just to be able to articulate general principles. If the malpractice claim is failure to join a party, the appellate court can't fix that, right? So are you saying
correct.
that AMFAC simply doesn't apply to failure to join a party or to preserve a claim?
First, I do agree with that. Second, I suggest that this case is in fact much stronger because in this case, as Mr. Leonard has just told you, the suit against Gosnell isn't even for the same things as the suit against the city. The Gosnell case is, Mr. Gosnell, you misrepresented the value of a property. I paid $895,000. I paid too much because you misrepresented the attributes of the property. The other case is city. Years after that, you concealed from me that there was a way to fix all of this, and therefore I lost a sale that I believe I could have had to the Hilton. They're not even the same claims, let alone the same case or the same lawyers.
So let me ask just one more general hypothetical. If a lawyer simply blows the statute of limitations.
Yes, sir.
And through different counsel, the client pursues the claim against this putative defendant. It looks bad. Statute of limitations defense is colorable, but she nonetheless pursues it and wins. Does she get to wait till her victory for accrual? Or would you say that the mere fact that there was an assertion of limitations, and she knew at that point that her former lawyer had missed the statute of limitations, that's enough for accrual?
What I would say, Your Honor, is the hypothetical you just gave, two responses. First, it's not AMFAC. It's not the rule that exists in this state today. If you want to hypothesize an extension of that rule, perhaps you can do that. But second, I would answer your question directly. The statute of limitations against the lawyer, there's a fairness and a balance here, too, when you consider the interest of the lawyers. The statute of limitations against the lawyer runs as it has always run, when you know or should know you have a claim against the lawyer and know or should know that you have been damaged, the fact of damage. And neither an insurance claim, a third-party claim, or another lawsuit, which may reduce or mitigate the amount of damages, none of that extends the statute of limitations under either our common law rules of accrual or under this narrow AMFAC exception. So I would suggest to you, as my time has run out, don't make any mistake about what's really going on here. You are being asked, without ever being asked, to adopt a brand new rule that extends AMFAC to an area, to a place, a third-party claim that might mitigate damages. That is not the law in Arizona, and you have never even been expressly asked to make that extension in this case. But that's the necessary implication of the appellant's position here.
Okay, and
Thank you.
I've taken, before you sit down, I've taken
Yes.
a lot of your time. I don't know if any other panel members have questions.
I want to be real clear on this.
Yes, sir.
Your position is that as of October 11th, 2007, Ms. Hyenga was confronted with a situation where, although the statute of limitations had not run clearly on a portion of a claim, on the remaining claim, if you will, if we can call it that, against the city, that it was necessary for her to abandon that and just go after Buse Gilbert, excuse me.
No, Your Honor, with all due respect, absolutely not.
Okay, so wait.
She didn't have to abandon anything. She pursued the city.
Stop. So, if that's going to be your position, then she pursued the city, but didn't know that she wasn't going to get the full amount of her damages from the city and had to proceed against Buse Gilbert as well.
Well, Your Honor, as I just said, the claim in the Gosnell case is not even the same claim that she's asserting against the city.
But I thought you argued in your pleadings that the October 11th, 2007 date, and the court found that that was the drop-dead date for the statute.
Yes, because when you read her two letters to see what does she know on that day, she knows she has a claim against the city, and she knows or believes that Buse Gilbert has failed to assert that claim. Does that claim directly relate to the Gosnell case? No. Can the Gosnell case final resolution resolve that malpractice claim? No. The Gosnell case does not even have as a claim in it, nor could it, gee, you failed to sue the city. That is a separate malpractice claim, completely separate elements, different lawyers handling it, different damages sought that we admit might have the ultimate effect of influencing the amount of damages she could seek in the malpractice claim, but that's all.
So when she comes in claiming a $4.8 million damage, gets $2.5 million from the city, and comes back to Buse Gilbert and says, I need you to kick in the other 2.3,
Yes.
You're saying those are completely different damages, completely different claims. There's no corollary between the two
That's
issues.
correct. Buse Gilbert will defend that case, saying that we did nothing wrong in failing to sue the city, either because we told you we weren't going to, or we don't believe there's a claim, whatever the defenses may be, and they are absolute, separate, and distinct from the claims that were pending in the Gosnell case, which is based, as Mr. Leonard has candidly told you, on an alleged 1997 misrepresentation by Mr. Gosnell about the permitted density on the property. It has nothing to do with Buse Gilbert's alleged failure to sue the city, and therefore capture the damages from an alleged sale of the Hilton that didn't even exist at the time of the alleged mistake by Mr. Gosnell in his misrepresentation case. Separate case, separate claims, separate counsel, separate damages, although the damages in one case might reduce the claim in the other.
Thank you, counsel.
Thank you very much, Your Honor.
Thank you, Your Honor. First of all, Arizona versus Kaloff, quoted on page 49 of my brief. Contrary to what we said in Kaloff, the principle applies to all attorney negligence, transactional or otherwise. The case of Tuller, which is an Arizona case, transactional lawyer fails to get a security instrument. Separate lawyer, separate case, sues the debtor. You have to wait until the suit against the debtor by the separate lawyer is over before you know whether the failure to get the security instrument caused any damage. Not was negligent. The failure to get the security instrument was negligent. But whether or not it caused damage has to wait until the case against the debtor. Because if the debtor pays, there's no damage. A number of other things. California, their statute is different from ours. It says it runs from actual damage. What do they do in California with a case like Tuller or AmFac? They say, sue the lawyer, but put it on hold until you resolve the other case. Then when you resolve the other case, then go back and pursue the lawyer. But you must sue the lawyer when you know you should sue the lawyer because you've been actually damaged. You just put it on hold until the other one is resolved.
Might be a better rule.
Well, Arizona has specifically rejected that and has specifically rejected Jordache. And that's in my brief. It has been specifically rejected. Arizona uses a bright line rule that says when the damages are not ascertainable because there's some litigation out there, you got to wait till that litigation out there is resolved. You just have to wait. And if she had waited until 2011 to sue the city, it was the resolution of the city case that tested the claim against Buse Gilbert. Let me make the claim against Buse Gilbert clear. Buse Gilbert learned, at least in 2005, that the city had lied in 2000. They didn't tell her. Had they told her, and told her that they had a conflict of interest and Paul Gilbert was reluctant to sue the city anyway, had they told her, go get another lawyer and check out a suit against the city for the 2000 misrepresentation that we just found out about, then she could have pursued the city at the right time. Now, there's still the issue, does all of this grow out of the litigation, the 2003 litigation? We take the position that it does.
Counsel, are you asking us to extend AMFAC? I mean,
No, AMFAC has been extended. AMFAC has been
to outside litigation.
Absolutely.
To litigation unrelated
the Tuller
to the
case, the
malpractice.
Kaloff case, unrelated. Well, okay, the litigation is related in that it's against the city, and it was in the 2003 litigation that the lawyers found out that there was such a claim. Let's assume that these two claims do not both come in the litigation. A lawyer trying a case in 2005 finds out that there's a claim against party X, but he doesn't say anything. Lets 2 years goes by, finishes his case, and then the client finds out that she has a claim against X, and X says, come on, your litigation counsel knew all about this in 2005. That is the negligence of Buse Gilbert. They failed to disclose to her what they had learned at least as early as 2005. We don't contend they should have filed suit because they had a conflict of interest, but they should have told her, your statute of limitations is going to run on X date, probably 2 years from when we found this out, and you should go to other counsel and look into. Now, the two letters. The letter against Buse Gilbert seeks 1997 damages. It doesn't ask for Hilton damages. This letter against the city asks for Hilton damages. Why? Why on the same day is she asking two different parties for two different kinds of damage? Because she has two different kinds of damage. She doesn't believe she has Hilton damages against Buse Gilbert. She is saying, why didn't you name them in this misrepresentation of the 120 units in 1997? She isn't saying, why didn't you join them because of their lie in 2000? She didn't know about it until October of 2007 and thought that they didn't know either. She thought they were caught as flat-footed as she was. When her new lawyer files a motion for a new trial, he files it on the grounds of surprise.
If there's nothing further.
Nothing further.
Okay. I'll let you go a little bit longer, but anyway. I did. Well, thank you, counsel, for both arguments. Very helpful. The matter is now under advisement. We'll issue a written decision in due course, and the court stands adjourned.